final matter to come before us this morning is in re MF, HF, and SF. Both sides will have 15 minutes to argue. If you're the appellant and wish to reserve any time for rebuttal, you can reserve up to 5 minutes. If you let me know when you get started, I'm keeping the clock and I can keep you apprised of the passage of that time. The court has read the briefs and we are ready to proceed with you. Also, we'd like to thank Judge Cannon. He is sitting in today for one of our judges on the 9th. Judge Cannon is from the 11th District.
May it please the court, my name is Barbara Weber, and I represent the appellant, Tracy Flowers. She is the mother of the 3 children that are the issue of this appeal. Oh, I'm sorry, I'd like to reserve 5 minutes for that. Thank you. She is the mother of the 3 children who are the subject of this appeal. They're ages 13, 12, and 10. The children primarily reside with their other Intel Children's Services involvement with her. And we believe that based on the evidence, it was against the manifest weight of the evidence that it was in the children's best interest under the applicable statutes 151-414 that father be given legal custody. While mother had some issues, there was no proof that father was better suited to care for the children. He himself had some cognitive issues and was given legal custody without ever being given a chance to show that he could carry through on things without help with Children's Services. If you look at the first factor to consider the child's best interest, it's the relationship with children who are going to significantly, other people that are going to significantly affect the children's interest. And there was no testimony presented as to how the father would interact with the children in this case. The GAL was asked if she had a chance to observe them. She said yes, but then she wanted to explain what the condition of the house was. She didn't explain or elaborate on how the father and the children interacted. Father himself did not testify as to his relationship with the children or his plans for the children as far as interacting with them. Mother herself had 6 witnesses that testified as to her relationship with the children and how they interacted. Father further had a girlfriend that lived with him. There was no testimony as to how her relationship was with the children or how she interacted with the children. As she lives with the father, her relationship with the children should be something that would definitely be considered. Yet there was no testimony about that. The other issue one of the other issues is the children's expressing the children's wishes. And in this case, there was testimony that prior to father's request for legal custody, the GL was going to recommend that the children be given back to mom. Then after father filed a motion for legal custody, she supported father's motion. So obviously at first she was willing to get on the stand and say that it was in children's best interest to go back to mom, which is kind of contradictory. Then she's turning around and saying now it's in the children's best interest to go with the father. So I'm not really sure how much credence can be given to her argument that those were the children's wishes. Further, the father, I don't believe, really demonstrated his ability to, the mother was alleged that hadn't followed through with the medical care for the children. But once Children's Services became involved, she did follow through with it. There was no evidence presented that the father would be able to carry through with their medical care if Children's Services was not involved. In fact, the caseworker, one of the children's counselors testified he didn't even know father. Up until this point, he'd never even talked to her about the children. His visits with the children had been inconsistent. And then basically, he'd not really been a major part of their lives until he was granted the emergency custody. I know Pelly in her brief alleged that his visits were inconsistent because mother had denied him visits, but that rightfully so, her trial counsel objected that because it was hearsay. Appellant, if that was the case, could have easily got on the stand and testified that she denied him visits, but he never did that. So an allegation that he couldn't see the children is really unfounded at this point. It's hearsay. And on top of that, there was testimony that, while I realize it's not a factor, there was testimony that the father wasn't, after he got legal custody, letting mother see the children, which really isn't in their best interest, because the children had been with the father, not with the father, but with the mother most of their lives. Really, basically, I believe if you look through the factors of best interest, it wasn't proven that, there was a lot of unanswered questions about father, and I don't believe it was proven that it was in their best interest, and because of that, I'd ask the court to remand it back. Thank you.
Counsel, this was done, finally, the objections overruled July of 2015, I believe.
I don't recall for sure.
Okay, well, there was an ongoing case plan
Mm-hmm.
and protective supervision.
Yes.
That was going to be reviewed in November. I know it's not part of the record in this case, but do you know if that was done?
No, because I was not the trial counsel, so
Okay.
no, I don't know.
And there was a provision to extend that for another 6 months if there were problems and whatnot. Do you know whether any of that's been done?
Unfortunately, no, I don't.
Okay.
Sorry.
Morning. May it please the court, my name is Kara Finnegan. I'm an assistant prosecuting attorney and I represent Lorain County Children's Services. As an initial matter, I would ask that the mother appeal at this point, that it should be either overruled or dismissed. The basis for that being that the initial brief actually applied the wrong standard. The initial brief applied RC revised code 3109.04, which is the applicable statute for best interest in a divorce, legal separation, or annulment action. However, the motion for further dispositional orders filed by Children's Services, and as well as the motion for legal custody for father filed by his counsel, were both filed under 2151.353 F1 and section 2151.415. Which is applicable in abuse, neglect, and dependency actions. So even though we did argue under the both sections in the brief, I would ask that as an additional matter that be overruled. I know counsel did reply, mother's counsel did reply to that. However, I kind of see that as a second bite at the apple. I think it was kind of just retooled so that it fit the proper statute. But I still would ask that it be overruled. However, in responding to mother's manifest weight of the evidence argument and applying the proper code, I would find that I'd ask you to find that mother's argument is without merit. Specifically applying the factors that initially to respond to mother's counsel's argument, she says that there was a case plan for the children to be given back to mother. The initial disposition was protective supervision. So initially the children were never removed when that case plan went into effect. It was initially protective supervision, the children were to be maintained in the home. However, following a hearing on father's motion for legal custody, the agency was presented with some very imminent concerns regarding the children and their safety in mother's home. At that point, there was a removal, and it became more of an action to return the children, to reunite children with mother. So just to address the concern about the GAL's position, I think initially, yes, she was in favor with the agency's position. We had some new information that came out after all parties agreed to the protective supervision, and at that point, she then changed her position as well. So I don't think that we can say that credence can't be given to her position when she came back and said, no, I feel the best interest is with father. I think based on the new information that she had received while this case pended, and again, this was a very lengthy hearing. Protective supervision was initially granted on the 22nd of September. It wasn't that the hearing on legal custody was completed until January 13th of 2015. So this was a long period of time. There were things going on while the protective supervision had been granted and while there were further hearings for the legal custody. So I think that has to come into play when considering whether or not the GAL was making a true and unbiased decision about her recommendation for best interest of the children. And just in regards to a manifest weight of the evidence argument, we're looking at a preponderance of the evidence, and there is no specific test or criteria. The guiding factor for this is essentially the best interest factors to be considered in a permanent custody case, even though that's clear and convincing, and here we're looking at a preponderance. So there was some argument in Mother's brief saying that the children had not made their wish, or father had not made his wishes known. I don't believe that there's really an applicable best interest factor under the permanent custody statute for that. But I would say that the fact that father retained, or I believe he was court appointed, I don't recall, I'm sorry. But the fact that father had counsel, had moved his counsel to file a motion on his behalf, was present for the hearing and had his counsel call witnesses, I think father very much was involved in his decision to try and take custody of his children. And again, I believe Ms. Weber stated that there were some problems going on. There were some cognitive delays for both parents. So I don't know that that can be, if father wasn't testifying and his counsel made that decision for him not to testify, I don't think that we can look at that as that father wasn't making his wishes known. I think counsel was making a best interest for his own client actually there in saying, let's bring in these other witnesses to testify on your behalf if you're not comfortable in presenting your own testimony. The next factor that mother addressed in her brief was the wishes of the child. And in that regard, mother is arguing that there was no in-camera interview, the wishes of the child could not be known, but I would argue that there was a GAL in this case, being a neglect and dependency case, who was able to talk to the children, investigate the placements, talk to the parties, and that through her own investigation, she was able to say what the children had expressed to her as their duly appointed guardian. So she did make those wishes known, and the children in her testimony had told her that they were comfortable with father. They were happy there. They appeared to be excelling in that placement. And her recommendation then back to the court was that she felt this was in their best interest. Another factor that mother addressed was the significant relationship, which is a best interest factor under the permanent custody statute. And in that case, she said that they appeared happy with father. I don't know that she spoke specifically to, I saw them interact this way, or I saw them interact that way, but she did testify that I'd been to the home. They seemed happy. They seemed to be doing much better than they were in the care of mother when I was at that home. And in regard to that, I don't think there was any argument that mother didn't express love for her children, but there were then concerns with the interactions between mother and those children, as well as some of the other significant people in that home, being maternal aunt, and some concerns voiced by the guidance counselor and the school nurse, who said that they had very much some concerns about maybe abuse going on in the home, that the children were being hit, that they were being hit with belts and cutting boards and things of that nature. So I think while it might be clear that mom loved the children, there was certainly some concern about the interactions going on in that home, and none of those types of concerns were voiced by father. And the children had been in his home for quite some time by the time the hearing was completed, for at least 2 months, a little over 2 months by the completion of the legal custody hearing, where the Children's Services had still been involved, GAL had still been involved and had been going to that home, to make sure, to check on the progress of the children. Additionally, there was some concerns about the cognitive capacity of mother and father, and that is raised by mother in her brief, talking about the fact that there were no scientific testing, there wasn't testing done at any sort of facility or anything. It was just based on the caseworker's observation. But I would say, given the caseworker's knowledge, based on her educational background, her experience in the field, and also the fact that she'd had prior involvement with the family. These children were actually adjudicated before protective supervision had been in place before, I believe, in 2008 or 2009. So this was not the caseworker's first exposure to the family. She was well aware of what the delays were, what the hurdles were for parents in trying to have them understand how to parent successfully and in addition, how to care for some of the special needs that these children had, some craniofacial issues for one of the children, some encopresis for another one of the children. And Mom argues that she was able to follow through with those medical concerns when Children's Services was involved. And I would submit that that is true. The concern being, though, that this was a concern initially when the agency was involved with the first grant of protective supervision. The caseworker testified that there were other instances where the agency became involved in an out-of-court basis, again for the same reason of medical neglect, trying to make sure that they were keeping appointments and meeting all of the special needs for the children. And that essentially if Children's Services wasn't involved, Mother was not meeting those needs. So it became more of an issue of Children's Services can't be involved forever. We can't always be looking over their shoulder, so we need to make sure somebody is able to meet the children's medical needs. And in that regard, once the agency empowered Father a little bit, made him aware that he did have rights, he was able to be involved medically and with the school. Once the caseworker attempted to work with Father on some of those issues about coming forward and being involved in the children's lives and that he had the right to do that, Father seemed to be following up on things much better and much more successfully than Mother was able to do. And Mother also considers visitation as one of the factors under the inapplicable statute, to which we did respond. However, in talking about it, there is a concern that Father wouldn't provide visitation. However, I don't think that's what the testimony has shown. The basis for that argument is that when Mother came back for the objection hearing, there was a request for more specific visitation. There was never any evidence or testimony taken that Father was not allowing visitation. It was just as agreed upon due to the concerns, I believe due to the concerns with Mother when visitation was unsupervised or when the children were unsupervised in our home that led to the agency to ask for emergency temporary custody. Visitation was granted kind of on a general basis, saying as the parties could agree, but to be supervised. So when it came back, it was not that Father was not allowing visitation, it's that she wanted it more specified. And additionally, in considering visitation historically, there had been concerns that Father was not getting visitation. There was testimony that he had not had a holiday visitation with his children in the years prior to LCCS becoming re-involved. So between the last involvement of the agency and the current involvement, Father had not spent a holiday with his children, and there was also testimony that Mother would withhold visitation as a punishment to the children. So I think that factor weighs highly in Father's favor if that were to be considered. The factors of, there's some other factors that are, some other factors that were considered under the statute was any past neglectful actions on behalf of the parents, and again, Mother was involved previously with the agency and had been found to be the perpetrator of the neglect against the children that led to the grant of protective supervision initially back in 2008, 2009. Just based on those considerations that Mother had addressed in her brief, looking at the best interest factors, I think that they weigh highly in Father's favor. And the court could have easily found, given that testimony, that legal custody was indeed in the best interest of the children to be granted to Father. Mother, by the caseworker's testimony, was working with Children's Services. However, the caseworker felt in her prior history with Mother, and again with this current involvement, that some of the issues with Mother were not real fixable. That she could do it on instruction, but wasn't seemingly able to grasp how to care for her children when the agency wasn't standing over her shoulder, guiding her, do this, do that. She wasn't really able to learn. And in that respect was relying heavily on the maternal aunt, who there were a lot of concerns where the children were almost scared of the aunt due to they were scared of repercussions of telling the caseworker anything. They were afraid that based on the reports to the school nurse and the counselor, that they would be punished in some way, generally corporal punishment, if they told anything to the caseworker. So I think, based on all of the evidence presented, that the court could have easily found that legal custody was in the children's best interest, and we would ask you to uphold that grant at this time and to overrule mother's appeal. Thank you.
Counsel?
Questions?
No.
Okay, thank you so much.
First, I'd like to address council's motion to overrule it based on the statute. Yes, I did initially do the wrong statute. Unfortunately, I do a lot of domestic work, and I did that. I did file a motion to amend it, and in her brief, she argued the applicable statute, which in my reply brief, I did also argue the applicable statute based on what she had argued in her brief. So I'd ask the court to, again, overrule her objection or her motion. As far as she talked about the GL changing her opinion, the father obtained emergency custody because there was an allegation made to the school nurse that there was no that the child had been hit. Yet there was no physical evidence on the child that the child had been hit. And that was what he got. So when she says that there was disturbing incidents that caused the GL to change her opinion, there was an allegation, but really not substantiated. Further, she addressed the fact that father didn't testify because he thought it was better that others could testify for him. Well, if he cannot testify for himself, I'm not sure how competent he'd be to care for the children. And the motion he made, it doesn't necessarily mean he was motivated because he wanted custody of the children. There was testimony by my client that he was inconsistent in paying child support. This could appear to be a good way to not have to pay child support anymore. Really, the GAL only had one visit to the father's home of all her visits after the children were placed there. And one visit to say the children are happy and everything's great with the father, I don't really believe is enough. Mother demonstrated that with her issues, she could comply with help. Father, again, we don't know because he was given custody without there being a chance to see how he would react with the children. And I do not recall there being testimony that he was doing better at following through than the mother, but I am not saying that it wasn't there. I just recall that. Further, the only testimony that the children wanted to go live with father was from the caseworker, which I addressed previously. That was overruled, her testimony, because it was hearsay. It was now on the visits, I'm sorry, but about the father being denied visits. And again, if that really was the case, and the father wanted that point known, he could have taken the stand and testified to that. So really, to say that he was denied visits, there's no proof of that. Again, I've asked the court to remand it. Thank you.
Thank you. Thank you both for your presentations today. The court will take a matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website.
Thank you.
Thanks for coming a little bit early today.
Oh, not a problem. I'm sorry yesterday.
I figured you were in court or,
I didn't get the message till later in the evening. I'm like, oh no.
So that's fine.
All right, well, thanks.
It worked out.
It's nice to meet you.
You too.
Have a good day.
You too.
Okay.
You got new hair since the last time we saw you.
Yes, actually, you're right.
Quite cute.
Oh, thank
Very
you.
flattering.
Thanks.
Have a good day.
You too.
Thanks.